Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning.
Hello, Your Honor.
We are on the record calling 22198-664. Doctors Harris and Burkill versus Sharona Fikes. Date and time for what appears to be our initial pretrial. Your appearances.
Thank you, Your Honor. Hal Burke, P69068, attorney for Doctors Harris, Burkill, and Wang Song on this case.
And what is your name, ma'am?
My name is Sharona Fight.
Okay. I picked up the wrong file here. 664. Ms. Fikes, is it your intention to represent yourself in this matter?
Yes, sir.
You, of course, have an absolute right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on Mr. Burke are binding on you. Do you understand that?
Yes.
All right, where are we on this file, people?
Your Honor, would you consider allowing Ms. Fikes and I to be in a breakout session? Like you mentioned, this is my first contact with her.
Okay, you know what I think I should do in the interest of efficiency? What
Yes.
I'm going to do is I'm going to open your written discovery. I'm going to give you a return date. Your return date with me will be February 28th at 10 o'clock. And I'll put you guys in the chat room. If you settle the case, come back to me. If not, get started on your written discovery, and I'll see you again February 28th at 10 o'clock.
Thank you, Your Honor.
Thank you.
We'll send out a written notice to both of y'all today. So let's see if I can make the technology work and get you to the chat room.
Thank you.
Can't always be sure about that. Breakout rooms. Okay, Burke. 5. Fikes. 5. Okay.
Good morning.
Morning, Counsel. How did you get here?
Hello, Judge.
Hi, you're in the wrong, I got the wrong guy.
Oh,
That's-
sorry.
I think my list jumped on me when I put somebody in here. Let's try Mr. Patterson, who I was trying to get in here. Yeah, this is a little bit better. Good morning. This is 22-198-906 Lint Chiropractic versus City of Detroit. Date and time for what appears to be our initial pretrial on this PIP case, your appearances.
Good morning, Your Honor. Mom was here on behalf of plaintiff P84247.
Good morning, Your Honor. Ben Patterson on behalf of defendant City of Detroit, P85118.
Okay, I have the 2.3028 disclosures from the plaintiff. Mr. Patterson, have yours been made?
Yes, they have.
Counsel, you got those?
Yes, Your Honor, I have them.
All right, now, then why are we still here? You know what each other's case is about. Why aren't we done with this file?
Your Honor, it looks like I received the initial disclosures a couple days ago, so we just need some time to review them and make an initial demand. I was hoping if Your Honor would allow us to go to case evaluation on this, if Mr. Patterson is open to the idea.
I'm actually not, Your Honor. I reached out to counsel's to Tim Hartner, who was listed on the file, and left a message. And we also already produced the claim file and the bus video on this case. This actually is a little bit late to the party. There's been several cases on this already. I'm happy to chat with counsel now that I know that she is the one handling the file, but I don't think this is a good candidate for case evaluation.
Okay, well, not a decision I have to make today. How much, counsel, is your claim?
Your Honor, our claim is for $18,762.
Is there ongoing treatment?
As of now, Your Honor, it doesn't seem like there is. Last date of service I have was about a year ago.
Okay, so we don't have to worry about whether this is within my jurisdiction. Okay, well, here's what we're going to do. I'll see you guys again February 28th at 10 o'clock. I note that both of the disclosures have been made. And let's get started talking on our file. Mr. Patterson, you say she's late to the party. I take it there have been other litigations involving this injured person?
There have actually 5 of them.
I know that.
They've all been resolved either on motion or on nuisance value settlements.
Okay, well, you guys get to talking. I'll talk to you again February 28th, at 10 o'clock. Thank you for coming in.
Your Honor.
Thank you, Your Honor.
And if you can give me a call on this one.
You guys want
Yes,
to chat room?
I will
I
give
can
you a
do that
call.
right now.
Okay, yeah, I'll
sure.
take a chat room, yes.
Put you guys in the chat room, then when you're done, just take off.
Okay.
Okay?
Thank
I'll
you, Your
talk to
Honor.
February 28th at 10 o'clock. Let's see if I can make the technology work again today. I've been successful once, maybe I can do it twice. Hey, you laugh.
It's funny. Thank you, Your Honor.
You laugh.
Thank you.
Y'all be safe now. Hello?
Hello,
What is your name?
my name is Mary Nelson.
Mary Nelson?
Yes,
Okay, can you hang on for just a second?
okay,
I think I have the other side.
okay.
Counsel, good morning.
Good morning.
Good morning, Your Honor.
This is file number 22-192-901. First Portfolio Ventures versus Mary Nelson. Date and time for pretrial. Your appearances, please.
Alexander Sarhan, P77252, on behalf of plaintiff.
And you are Mary Nelson?
Yes, I'm Mary Nelson.
Okay. Ma'am, is it your intention to represent yourself in this matter?
No, I don't have I need a lawyer.
Okay, well then,
And,
what'd you say? Go ahead, ma'am.
and, I was a victim of a domestic violence.
Well, ma'am, this is not a domestic violence case. This is a civil case.
I understand.
In regard to a lawyer, if you want to hire a lawyer, ma'am, you have a right to do that. But this is a civil matter, not a criminal matter, and the court does not provide lawyers for litigants in civil matters. What you could do, there are a number of free legal services available. You could go online to the State Bar website or to the Michigan Supreme Court website, both of which will give you a list of places that you can go to seek legal aid without you having to pay for it. Okay. So what I'm going to do, since you guys have just gotten started, I'm going to give you a return date. Your return date with me will be February 28th at 10 o'clock. I'm going to open your written discovery. Discovery, Ms. Nelson, is your opportunity to learn about through written means, such as written questions under oath that are called interrogatories, requests for admissions, or requests for production of documents, is your opportunity to learn about the claims and defenses of the other side. If you intend to represent yourself, again, that's your constitutional right, but you will be bound to the same rules as the lawyer. If you intend to get counsel, I would urge you to get that done immediately. Have the lawyer file the appearance. The appearance is a document by which the lawyer says he or she will represent you. I will see you guys again February 28th. February 28th, your written discovery is now open. Is there anything else we can accomplish today?
Well, Your Honor, I
Well-
just wanted to let the court know that the defendant did speak to someone in our office and made our office aware of some certain circumstances regarding this matter. And we did send her a hardship packet, and that was sent on January the 18th with sort of details that we would need, copies of certain things, and requested that she return it. And that was done after she called our office, which it looked like it was roughly 13 days ago.
Ms. Nelson, you have that information they sent you?
Yes, I had the information.
Okay, then you need to get it back filled out to them as soon as possible.
Okay, so what I supposed to,
I'm sorry.
okay, what I need, hello?
Go ahead, ma'am.
Yes, what I need to do, I need to call out of state to get my discrete report because, like I said, I was a domestic violence.
Again, ma'am, that's not something
Okay.
that I'm going to handle today. We'll talk to you people
Okay.
again February 28th at 10 o'clock. I would urge you, ma'am, to return that hardship package if that's what you choose to do. Your written discovery is now open. Thank you both for coming in. We're off.
And, Your Honor, finally, with discovery being open today, is it for 30 days or and then coming in
Well,
for a
it's open
pretrial?
today. I'll see where we are the next time we're
Okay.
together. Typically,
great.
counsel, I let the parties keep discovery going as long as they are doing something.
Mm-hmm.
When nothing's being done, then, or if the parties tell me discovery's closed, then I'll close it.
Sure. Thank you, Your Honor.
Thank y'all both for coming in. Let's be safe. February 28th, 10 o'clock is our next pretrial. Your written discovery is now open.
Great. Have a great day, Your Honor. Thank you.
Good day, sir. We are on the record calling 22188-192 Credit Union 1 versus Tavares Head. Date and time for a motion to reinstate the file. Your appearance.
Good morning, Your Honor. James Zahn appearing on behalf of the plaintiff.
You remember the State Bar of Michigan?
Yes, I am.
Then
P
you probably have.
69241. P 69241, Your Honor.
Mr. Zellin, have you heard from counsel or the defendant on the other side?
I have not, Your Honor.
Have you received any pleadings from the other side?
I have not, Your Honor.
This matter is set for hearing today at 10 o'clock by a notice sent to the parties on January 5th. It's now after 10:15. Let's proceed, sir, with your motion.
Your Honor, we are seeking to reinstate our case. Defendant was served timely. For whatever reason, the court didn't receive the default judgment we had submitted and dismissed the case for no progress. I would ask the case be reinstated and allow plaintiff to submit a default and move forward.
Well, counsel, I got a problem here.
Okay,
Looking at the file, I see that on October 21st, the court sent out its notice of intent to dismiss. The case was not dismissed until November 30th, more than 30 days later, and no action was taken by your office in the meantime. Why did you not respond to the notice of intent to dismiss? That's the whole purpose. Of sending those out. Hey, something's wrong. Maybe it's the mail, maybe it's the court, maybe it's your office. Hey, there's something wrong.
I understand, Your Honor. It appears in reviewing my file, I did not receive the notice of intent to dismiss. I have the card for the dismissal, but I do not have the postcard for the notice of intent to dismiss.
Okay, I would also point out to you in my review of the file,
Okay,
filed your motion, and that motion I know was filed back in December 29th. That was the first time, sir, that you included in your pleadings a military status report for the defendant. I can't enter a default or default judgment without a military status report indicating that the defendant is not actively in service. So
okay.
even if we had received your pleadings, they could not have been entered because they were not complete.
I submit the military notice when I submit every default to your court, Your Honor.
I'm looking at the file, and the only military affidavit here is stamped December 29th, the same day your motion came in.
Okay, and I would have sent it prior when I submitted the
default, yeah, right. I
Default.
understand that. And that's the point I'm making. Okay? For
Mhm.
whatever reason, you didn't send it, the post office didn't deliver it, we didn't put it in the right file. There is no status report for the defendant's military status until the one that came in with your motion. That's the point I'm trying to make here,
Okay,
which again puts me back in the same situation. Why there's no response to my notice of intent to dismiss. You are aware, are you not, that the court's registers of action you can access online?
I am aware, Your Honor.
So if, let's say, for example, you send in a default and you don't see any action, you can check out online to see what's going on.
Okay,
So that's what needs to, I think you need to get that a little more attention. All right, your motion is unopposed, sir. I've had a chance to review the pleadings. It appears that the court granted a motion for alternate service in this matter, and that the service was perfected as directed by the court. First-class mail, certified mail, posting by a court officer within the time permitted by the second summons. Your unopposed motion to reinstate the case is therefore granted. So what I'm going to do is I'm going to grant your motion to reinstate the case. Let's see here. So I would suggest you send me in a default.
okay.
Thank you, sir.
Thank you, Your Honor.
Have a good day.
You do.
All right. We are on the record. This is file number 22-188-207, Universal Collections LLC versus Ayanna Johnson. Date and time for an adjourned motion for summary disposition filed on behalf of the plaintiff. I note for the record, could I have your appearances? Excuse me.
Judge, may I please court? My name is Attorney Richard Bruce, and I'm the attorney of record. And I'm also the petitioner in this motion today, my bar number 35222.
Darlene Lynn Petrosky, P36759. I'm here standing in for Brant Lisinski with Lakeshore Legal Aid on behalf of the defendant, Ayanna Johnson.
All right, the record should reflect that the defendant, Ayanna Johnson, is present on Zoom, but since she has counsel, is muted. Let us commence with our motion for summary disposition.
May I go forward, Judge?
I think it was your motion, so I suggest you do.
Thank you, Judge. This is a case that's a one-time assignment from a rental unit that was a lease agreement with Motown Rentals and defendant Ayanna Johnson. Now, it's pretty cut and dry, and it's the type of landlord case that you see all the time in all the district courts in Michigan, where you had a lease agreement with the defendant, certain amount of time, the lease called for payments per month, the lease had all other terms and conditions, and then the defendant moved out, and there was some damage to the unit, which was attached to the complaint. There was a summary of that. You granted discovery. I sent requests for admissions. I sent production of document requests that defendant to prove any and all documents or provide any and all evidence that she will rely upon at the time of trial to prove a meritorious defense. And I sent interrogatories. None of that written discovery was answered timely, even after defendant lawyered up, as the term of art is, with Lakeshore Legal Aid. And as a matter of fact, it appears from the written answer to my motion for summary, for lack of a better word, Judge, defendant looks at the facts that I recited, files an answer, attempts in a very tardy fashion to answer all the written discovery, and then says something to the effect, or concludes something to the effect that, well, the judge can only let me extend the time. Well, wait a minute. Why wasn't a motion filed months ago, not an answer to a motion for summary disposition that's brought under the court rules timely? And furthermore, when I looked at what purports to be a meritorious defense in the answer to the summary disposition, all I see is irrelevant information and hearsay. What do I mean by that? It appears that all through this action, defendant has been fixated, and I use the word properly, fixated on the fact that she had a leaky basement, water in the basement. That may be why she moved out. I broke a lease back in 1983. I moved out, but I still had to pay to the damages I caused to the unit by putting nail holes and various and sundry other things, and it came off of my security deposit. So therefore, Judge, I believe that in the foregoing, that defendant has failed to allege a meritorious defense on which a claim can be granted. Judgment is properly laid, and the amount of the complaint of $5,935 plus costs and interest. And then I rest, but before I rest, Judge, depending, after we hear from sister counsel on her oral argument, this is a new attorney. And I really haven't spoke to her in breakout rooms before. You know, I spoke to her predecessor, Brant, Lisinski. And so I wouldn't, well, let me see, how can I say that? I would suggest gently that after I hear sister counsel's oral argument and before we make a ruling, Judge, that I would be very happy to go speak to this attorney on the record today in the breakout room.
Ms. Petrosky.
Yes, Your Honor. Here's, in this particular case, The individual defendant did answer the discovery. The plaintiff was put on notice that she did not cause the damage. One, that two, she was disputing the amount of damages. Three, that she did not agree with the authenticity of the documents. And four, she answered the request for admissions. And if we look at them, the court has the discretion, to excuse the deadline or to offer the defendant a time to redo the request for admission, so they're in a form that meets plaintiff's desire. But the request for admissions basically says the same thing. She didn't cause the damages. She doesn't agree with the amount. And then and that she never received the statement on account. And I didn't see that in the pleadings unless I wasn't considering the exhibits properly. Furthermore, she did send documentation in response to the request for production. She did send pictures of the basement. The damages are any that water in the basement if it caused damage to the furnace, a water heater, or any of the appliances, she would not be responsible for that. Part of that is when I look at plaintiff's motion, I don't see what specific damages they're talking about. There's just a number. But anyway, she did send pictures. She also sent 2 BC Detroit engineering reports that were done while she was living there that I had attached to the supplement, which she also sent to plaintiff's counsel. And she attempted to upload or download a video to plaintiff's counsel, and the system would not take it. However, she did indicate to me that she did not contact their office to see if there was another means of giving them a copy of the video that she took. So essentially, plaintiff was on notice that the claim was being denied, the amount was being denied, the basis and the liability was being denied. And so I don't see where there's any prejudice to plaintiff having this motion being denied.
Okay, I'm prepared to rule, but at the request of Mr. Rosen, I'm going to give y'all 5 minutes to work it out. If you can't work it out, then I'll make a decision today.
Okay.
I already have my idea what I'm going to do. I'm just telling you.
That's why I chirped up.
So I'm going to put you guys in the chat room. Y'all come back to me when you're done.
Thank you, Judge.
Okay, I'm going to put the lawyers in the chat room and put Ms. Johnson back in the waiting room. Y'all come back when you're ready.
All right.
Broski, in one. Rosen, room one. Okay. Ms. Johnson back in the waiting room. Yeah, cool. Hello? 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 Hello?
Hey, can you hear me?
Yes. What is your
Okay,
name?
I can hear you now. DeVar's Head.
Mr. Head, I take it you're here on case 22-188192, Credit Union 1 versus Devaris Head. Is that why you're here?
Yes, sir.
Sir, you came here after 10:30. This matter was scheduled at 10 o'clock. I called the motion after 10:15. You had not appeared. You had not filed any responsive pleadings. I granted the motion and I'll be sending out a copy of the order today.
Okay, what exactly is on the motion? Because I haven't received any paperwork.
This was their request to reinstate the case, sir.
Just to reinstate.
Yes, sir. I'll send that order out to you today. Thank you for coming in.
All right.
Have a good day.
You too.
Okay. We are back on the record with 22-188-207, Universal Collections versus Ayanna Johnson. Give me a second to let Ms. Johnson in and we can get started. So, Mr. Rusin, Ms. Petrosky, were we able to settle the case?
Well, I think so, Judge, but we've got a dollar amount that we agreed on. The open end is $1 per month to be paid beginning March 1. And opposing counsel wanted to talk to her client, which, as you know, is in your waiting room and not in the breakout room with the attorneys. So at this time, I would turn to sister counsel. She may have to speak to her client about what monthly dollar amount, so we can firm this up with a full settlement that I can put in writing, and file with the court.
Ms. Petrosky?
That's absolutely correct. We seem to be on the right page. We just want to make sure we got, the chapter and the course
All right.
perfect so that the client can follow through.
Then let me put you and Ms. Johnson into a chat room.
Okay,
Y'all come back to me when you're done.
okay.
Mr. Rusin, I'll put you in the waiting room.
Thank you.
Thank you, Your Honor.
All right, so I'm gonna go. Johnson. Room 6. Petrosky. Room 6. Okay, that's there. And Rusin back to the waiting room. Okay.
Your Honor, we are back.
Yeah. All right, we we seem to be back on file 22-188-207, Universal Collections versus Iona Johnson. Where are we, folks?
We have a settlement.
All right.
I will let Mr. Rusin put the terms on the record. And if Ms. Johnson has, if that's not her understanding, she can wave at me, but we went through it.
Okay,
All right, Judge, if I go forward, Richard Grusin for the record, bar number 35222. This is a case where the complaint was filed, Your Honor, in the amount of $5,935 even. Judge, the parties have agreed to settle this case whereby the case will be dismissed with payments being made during the time of the dismissal stipulation, where defendant will pay $1,000 beginning at the rate of $100 per month, beginning March 1 of 2023. And then each first calendar day of the month thereafter, the stipulated order that I'm going to send to Attorney Petrosky based on her email that she gave me will have that time is of the essence in these monthly payments. If defendant doesn't pay on the first, she has a 10-day grace period. But if she doesn't pay after the grace period expires, then there will be a reservation of rights, as it were, for the plaintiff to come back to the court, file the appropriate affidavit of non-compliance, and have the case reinstated on the docket. And the original amount of the complaint that I stated of $5,935 even, plus statutory cost and an attorney fee of $75 and less actual payment received. But in talking to opposing counsel, I'm very, very confident that the case is going to be off the docket forever based on full performance of the settlement. I will prepare the stipulated order, Judge, because I've done this time and again. I have sister counsel's email address to facilitate that. And once I received her countersigned copy, I will directly file with the court. I anticipate, well, I would say next week, but I'm going to be out of town. So I would say within the next 10 days.
10 days to 2 weeks.
Mr. Petrosky, did you hear those terms?
I did, and that is our understanding, Your Honor. I anticipate that we will have it back to you no later than 2 weeks. He's saying 10 days, but I've got to, I've got upward people to check off on it, but it's a deal.
Ms. Johnson, unmute yourself. Did you hear the terms of the agreement?
Yes, I did.
Did you understand the terms of the agreement?
Yes, I did.
And do you agree to those terms?
Yes.
Okay, thank you. All right, then what I'll do is I will dismiss the matter without prejudice. Looking forward to your closing documents.
Thank
Now,
you.
I can just point out that all these trees died for no reason,
And there are 3 new golf courses in the rainforest.
okay? Y'all could have called me yesterday and I wouldn't have done the analysis and written an opinion.
I'm curious as to what it was, but that's okay.
Yeah, I'm sure you are.
Mhm.
Me too.
We'll
Thank you.
maintain, how's that, creative ambiguity.
Creative ambiguity. I like that.
Yeah.
All right. Thank you, Judge.
You don't get to see the cards unless you go to the end of the hand.
All right.
Oh, but I want to peek.
Thank you all for coming in. I look forward to your paperwork. Just be safe out there.
All right.
Thank you, Judge.
Have a great day.
Bye-bye.